Mr. Cohen.
Good morning. May it please the Court, my name is Andrew Cohen. I represent the appellant children who wish to return home in this case. The juvenile court removed my clients from their home based primarily on an error of law, that the children's hearsay statements that they were hit by their father with a belt are admissible as statements of a party opponent. Now, that was not the law in October 2006, the time of removal, and it should not be the law going forward.
But they were party opponents, weren't they? I mean, why weren't they party opponents? They were contesting the removal. Right?
That is true. And technically, the party opponent rule should apply. They were adverse to DSS, and DSS offered their statements against them. So technically, it would appear, at least on a superficial reading of the rule, that it would apply. But there are several problems applying the admissions rule as to children's out-of-court statements. The main reason is that it would really turn the rules of evidence on their head in care and protection cases. And there are also due process problems. I've addressed them all in my brief, but I want to start today with the evidentiary problems.
Can I ask you, just before you get to that, let me understand. This is a temporary custody hearing under Section 25. What is the issue that is to be determined in that hearing?
The issue to be determined is the same standard that applies in a Section 24 hearing, which is an emergency removal hearing, which is whether the children are suffering from serious abuse or neglect, or whether they're in immediate danger of serious abuse or neglect, and that immediate removal is necessary to protect the children. If the court finds by a fair preponderance of the evidence that that standard was met, it can remove the children. That's what this court stated in Care and Protection of Robert.
So this standard is this standard is different than this. Is it different than the standard that would be applied in an emergency hearing?
No, Your Honor, it's the same standard.
But so the emergency petition was denied, and this was a subsequent hearing.
That's
correct.
But
the same standard, same issue?
Same standard. This court in Care and Protection of Lillian and Manuel stated that it's the same standard that applies.
Thank you.
There is a lurking question here about whether procedural, which you may have probably aware of, I think you are, you briefed it, whether these kinds of cases should come up here on 211.3. You're familiar with that issue?
I am, Your Honor. As this Court's well aware, parents and children have important substantive due process rights to family integrity. Now, when a trial judge takes the awesome and terrible step of removing children from their home based on a lower standard of proof, fair preponderance, there has to be some form of review available to make sure that there was no error of law and that the Robert standard of fair preponderance was met.
And I take it has to be 211.3 because the appeals court statute 231.118 doesn't cover juvenile court?
That's exactly right. There is no recourse to an appeals court single justice. And while there is recourse to a 3-judge panel of the appeals court from appeals of final judgments, final judgment in this case is far, far away. Now, this court has for decades, and the appeals court has for decades, held that hearsay statements by children in care and protection cases are not admissible unless there is a hearsay exception that's applicable. Now, DSS in its red brief cites many cases for the proposition that children's hearsay is freely admissible in these cases so long as the children are available for cross. But that's not the law. All of DSS's cases that it cites in the red brief, Carla, Inga, Mary, Leo, Tracy, concern child hearsay statements in court investigator reports. And this court did create a narrow hearsay exception for court investigators' reports where all hearsay is admissible in court investigator reports from children, from adults, subject to the party challenging that hearsay being able to call the declarant in order to rebut the allegations.
And were there any such reports in this case?
There was not. There is no court investigator's report in this case. Those cases are all completely inapplicable. They are not relevant to this proceeding.
Can I interrupt you again on the procedural point? I'm sorry to take you off the other point. I assume you would agree we could just direct that these appeals go to the single justice of the appeals court, could we not? much
Yeah,
as we did with domestic violence 209A orders.
Yes, I think this Court could.
I know the statute
Although the
is-
statute does say that there's no single justice appeals court availability for juvenile court orders, I suppose this Court could fashion
Okay.
an appellate remedy.
All right.
Mr. Cohen, assuming that we did something like that, from, and this may be the first time you're hearing about it, would that mean that there was or was not an appeal from that order to the full appeals court, and then an appeal from that order to a single justice, and then an appeal? In other words, what are you looking for here? You're looking for some appellate review. In other words, if you take a 211.3, you come right up here, and generally speaking, there's nowhere else to go. If we send it to the appeals court, would you be satisfied if we said, that's the appellate review, and you can't take further appellate review from that?
No, Your Honor, I would not be satisfied with that. These are very important.
Well,
substantive-
technically, all orders of the appeals court single justices, no matter what they are
Go to the-
technically reviewable here under 211.3, and we do get that.
Yeah, I was just wondering, I mean, in these cases, speed is of the essence, and because you're talking about the impact on very young children. So,
That's right. And these are very important substantive
how many
due process
cases? You obviously have pretty broad experience, and I can ask DSS the same time. But in a given year, how many such appeals are we talking about?
Your Honor, in terms of potential 211.3 cases?
Correct. Or potential appeals from this kind of judicial order?
Very few. We have for years at CPCS taught our trial lawyers to take 211.3 petitions whenever they're aggrieved by a temporary custody ruling. And as this Court knows, there just haven't been that many 211.3
Yeah, I take
petitions.
it this one's a little quirky because, and maybe I'm wrong, but the children undoubtedly wouldn't testify for some reason. In most cases, the children will testify, or a lot of cases they will, I guess, won't they?
Well, Your Honor, perhaps they should. Unfortunately, children rarely testify in
Really?
these cases.
So most of these cases are resolved with social workers and others, police and so forth, putting in the evidence by way of hearsay? Or direct
No.
physical observations?
No, physical observations through official records. Hearsay, this Court's made very clear that hearsay is not admissible in these proceedings, but for court investigator reports and guardian ad litem reports.
Well, hearsay unless it's a recognized hearsay.
Unless it's an exception, that's
Correct.
right.
Yeah.
And tell me again, why doesn't it qualify as a statement of a party opponent?
Well, technically, it appears that it would, but there are a couple of very important reasons why it can't in these cases. One is the evidentiary reasons. This Court, again, has repeatedly said that child hearsay is not admissible in these cases unless there's a recognized exception. But one exception that's never been applied in these cases for child hearsay is admissions or statements of a party opponent. In practice, it doesn't work that way. Juvenile courts, until this one, have not admitted children's statements as statements of a party opponent. And in adoption of Paula, this Court rejected application of that doctrine to children's out-of-court statements. And going forward, this Court should not apply that rule either. Because applying a statement of a party opponent rule to children's hearsay statements would effectively wash away all other hearsay exceptions for children's statements. For example, and actually let me just take a step back. It's important to keep in mind that children are always adverse to some party in a care and protection case.
Well, so is a parent. Do we say that the statements of a mother or a father are not admissible as
No,
party
Your Honor, and
opponents?
they are admissible. This Court in adoption of Larry made clear that a parent's statements that are made out of court can be admitted by DSS. But if a child is adverse to everybody, the child is always adverse to someone in a care and protection case. If the child wants to go home, the child is adverse to DSS. If the child wants to live outside the home, the child is adverse to the parent. If the child wants to live in a placement of his or her own choosing, the child is adverse to everyone.
But isn't it, but that's because the issue in this case is temporary custody. If the issue in this case were the termination of parental rights, would the child even be a party in such a proceeding?
Well, this Court has not yet definitively said whether children are parties or not. We've taken the position in this appeal that children are essentially parties, or at least it's not necessary to reach that issue.
Because in a termination of parental rights case, the question is the fitness of the parent, right? And in that case, the children really would have no role as being adverse parties or not. They'd just be witnesses.
Well, children are accorded essentially full party status at all evidentiary hearings in these cases. Remember, children have important constitutional rights to substantive liberty interest rights to family integrity, just as adults do, and their rights are at stake in these proceedings. I realize my time is just about up.
It's up, but you may make one more point.
Children's hearsay statements, this Court has for decades crafted very elaborate, careful hearsay exceptions for children's out-of-court statements in these cases. If we allowed children to make children's out-of-court statements to be admitted as statements of a party opponent, children's statements in hospital records would come in. Children's statements to police officers and police reports would come in.
Spontaneous utterances. Spontaneous utterances.
Well, those would come in anyway as a hearsay exception. But this way, children's statements to experts would come in. The expert could freely take the stand and testify to everything the children said. This Court has...
But they can do that with parents.
They can do this with parents, but they can't do this with children.
But why not?
Well, again, it would wipe away years of hearsay exceptions that this Court would make. It would be a sea change in the rule of evidence.
Essentially, as I understand your position, of course children, the battle is over the child. And I'm not using this in a legal sense, but the battle is between, if there is a battle, it is between the state becoming the custodial party and the parent becoming the custodial party.
That's right.
Those are the adverse parties. Those are the adverse parties.
That's right. And
now, there may be some cases of children who are older children where they want neither parent nor DSS, where they want to become their own custodial person. We don't recognize that. Somebody has to have custody over the child, and the fight is who has custody. The reason it seems to me why we have crafted these careful exceptions is because for children, let's assume that children had statements, well, you understand my point. The real adverse parties here are the custody, the fight over the custody, not the child.
That's right, Your Honor, and it raises perhaps the most important point, my constitutional argument, which is that in many ways it is meaningless to have evidence admitted against a child, because you cannot admit a child's statements, hearsay statements against the child in one of these cases without also negatively impacting the parent's due process rights. This Court in Robert said that you need to have a fair preponderance of the evidence that the child was at risk of harm. A standard of proof is meaningless unless it means a quantum of proof necessary of evidence against the party whose rights are being abrogated by the state. And the father's rights in this case are being abrogated by the state based largely on evidence admitted against the child that DSS virtually concedes is not admissible against the father. DSS doesn't brief that issue.
Thank you, Mr. Cohen.
Thank you very much.
Ms. Krasner?
Here, please, the Court. I'm Sherrie Krasner, and here today on behalf of the appellant father. Yesterday, I was served with a motion to strike father's appearance based on some technical errors made by trial counsel in perfecting the appeal. I have filed a written opposition with the Court this morning and would ask, with the Court's permission, that I be allowed to argue.
So your position is that the father is an appellant?
That is correct.
And he was a petitioner before the single justice?
Yes, he was. He inartfully called the document that he filed a memorandum, but it was, in fact, a petition.
Okay.
Well, you don't have to. You can address the substance, and we will deal with the motion. I haven't seen the response.
The motion later. Why isn't this an admission of a party opponent? Why isn't it? The kids are part and parcel of this whole thing.
I would respectfully refer the Court to Paula, in which, specifically in footnote 12, in which the court states that children are not party opponents at
We're
this.
here to see if Paul is right or wrong.
Correct. But when
I mean, some of the most probative information is going to come through the statements of the children.
Right.
We're going to make that all go away, and what are we going to rely on?
We're going to rely on the social workers, on the investigators, on people who have direct observation of the children, on the father. There certainly were people that could have been called in this temporary hearing.
And again, the children could have been called, I assume. Sure. Why weren't the children called, out of curiosity?
I was not trial counsel. I do not know. I would suggest the age of these children, there might be an issue with their competency. We don't know from this record whether these children...
If we adopt your rule, though, won't, and Mr. Cohen says the children are very infrequently testify, and for good reason, their age, they don't want to be caught in the middle between the DSS parents and so on. Well, aren't we going to end up with a scenario where they're going to be called constantly and made to testify, further traumatizing them?
We have investigators, we have assessments, we have exceptions to the hearsay rule where children's statements can come in for their state of mind. There are other ways that the opinions and expressions of the children can come in under a recognized exception to the hearsay rule that would not force children to be...
If you know, in the Paula case, this footnote that you're relying on, I haven't looked at it, was that an issue in the case, or is that what we call a dicta?
It was not an issue in the case. It was dicta.
Right.
And that was also a petition to terminate parental rights.
Yes, it was. Yes, it was. I'd like to address, however, the issue that DSS raises in its brief, that there were problems with father's failure to essentially echo the objections made by the children. Children's Counsel objected to the admissions of the children's out-of-court statements, and this was an appropriate objection, again, based on the clear language in Paula that such statements by a child in this type of proceeding at this stage cannot come in for its truth. Had father's child counsel objected, he would have been making the same objection for the same reason. Appellate courts declined to entertain objections to evidence made on appeal for the first time.
Well, first of all, it would be a different reason. It would be a different reason, wouldn't it? I mean, if the statements of a party can come in as against that party, they certainly are not admissible against another party, right?
Correct.
So wouldn't the objection be, whether they're admissible or not against that party, they're not admissible against me, and at the end of the day, it's my custody rights that are affected, and so that should be excluded from consideration.
But they weren't being offered for that. They were asked to come in as admissions. The objection was made that they were not admissions, and father would have been echoing. He would have been saying that's admissions. I'm not the one admitting. It wasn't an adoptive admission. I wasn't there. I didn't acquiesce by my presence. This is coming in as the child's admission and should not come in.
Or I won't belabor the point. Go ahead.
Although there's no case on point in Massachusetts on this issue of multi-party litigation, this court has recognized in GEB versus SRW that there is no error when a party fails to make an objection a second time to the admission of documentary evidence when the objection has previously been made and preserved on the record. Similarly, too, the appeals court recognized in Commonwealth versus Lara that that court recognized that defense counsel should not be faulted for failing to persist in objections that had been proven unsuccessful. I would also direct this court's attention to the commentary from the National Institute of Trial Advocacy on Federal Rule Evidence Rule 103. Those expert commentators concluded that if both a trial judge and an offering party have been properly informed of the nature of objection, that counsel in multi-party case that share a common defense should not be considered negligent in not making the same objection. They call that piling on, and I would suggest that piling on doesn't add to the litigation process, particularly in the overburdened juvenile court.
Thank you, Ms. Krasner. Your time is up.
Thank you.
Mr. Palliser?
Pariser, Your Honor.
Pariser,
Thank
thank
you.
you.
Brian Pariser for the department. I apologize for my hoarse voice this morning. I'd like to first address the question of whether this case is properly before the court under 211.3. Clearly, the department does not argue that there's not a substantive right at stake here with regard to custody of children. But there is a further question as to the nature of that right and whether it can be remedied through other means. I would direct this court's attention to its decision in Care and Protection of Robert, where the court noted that at a temporary custody hearing, while there was clearly a substantial right at stake, and without minimizing that right, did note that it was of a lesser nature than were this a question of custody or termination of parental rights and final judgment.
But that, of course it is, but that doesn't help. Because there may be gradations, but it's a substantive right and there's no appellate process.
Well, it does help, respectfully, Your Honor, in that because it is a temporary order and because that order will be subsumed in the final judgment.
And what's the period of time between the temporary order and the final judgment?
Well, it varies from case to case.
Could it be months?
The rule, the new juvenile court rule that was propounded by this court, requires a trial within a year of the filing. Now, that's 12 months. But I hasten to bring to the court's attention in this case, if court looks at the supplemental appendix filed by the department, there is a trial scheduled already.
But if you were right, a judge in the juvenile court could refuse to give a 72-hour hearing.
Well, that's
that issue was dealt with under 211.3. That's how it got here.
Yes, and I apologize.
If there was no interlocutory remedy, we could go back to that same problem.
Well, the department doesn't argue that there's no interlocutory remedy under any circumstances. I merely started with the question of the lessened nature of the right.
Is there, or isn't? I mean, if it's not 211.3, what is it?
Well, I think there is a right to review a 72-hour hearing under 211.3, provided that it presents extraordinary or exceptional circumstances. This court has always used that power sparingly and has only applied it to
But we do that in every case.
But essentially, respectfully, Your Honor, the appellant's argument is that every single temporary custody hearing is per se extraordinary. That is their argument. There's there's a substantial right.
What you're saying is, okay, they can file a 211.3, but it ought to be summarily dismissed because it's just a regular one, unless we look at it and it's got something, a barn burner in there. Is that what you're saying?
I think that's right. I think the court needs to see whether it's an exceptional temporary custody hearing.
Well, we may do that, but it wouldn't be kicked out because it's improperly here under 211.3, right?
I'm sorry, Your Honor?
There's a difference between saying we take a look at it. It's properly here under 211.3. We take a look at it, decide that there's no obvious error of law, and therefore dismiss it on that basis. And I don't think Mr. Cohen is arguing otherwise. He's not saying you've got to have a full-blown hearing on every one, as opposed to saying essentially the clerk of court for the single justice session kicks it out saying there's no right to a 211.3 review.
Well, in any case, I imagine there's still an assessment of whether the situation is exceptional or not. And to go back to Justice Spina's point...
No, sometimes we simply say you don't have a right, you can't come here under 211.3. You can't come here under 211.3.
Well, that's if there's another remedy, for sure. But if
there's a substantive right.
Certainly if the single justice looks at it and says, yeah, there may not be another remedy technically, but there's nothing exceptional about this case.
Right.
That would be a basis to dismiss the petition, right?
I think it would
Without
be.
getting into the merits.
I think it would be. And to go back to Justice Spina's point about whether anyone could have relief, if the juvenile court declined to provide a 72-hour hearing, well, clearly that would be exceptional. And I don't think anybody would argue.
If the juvenile court awarded temporary custody to the department without a hearing and an opportunity, without notice and an opportunity to be heard, there has to be some appellate review. So the question is simply a jurisdictional one.
Well, I think there's a difference in what Your Honor has put forth. If custody was given to the department without a hearing, that would be exceptional. That would be a clear violation of the statute and a clear violation of due process rights. That's not this case. Well, there was a full hearing in this case.
This is extraordinary, isn't it? This raises this whole evidentiary issue. I guess your point is, well, it can be addressed in a full appeal later.
Yes, Your Honor. I mean, this is not an extraordinary temporary custody hearing. If you look at this hearing, essentially what the appellants are arguing about here is one evidentiary ruling and a weighing of the evidence. They dispute an evidentiary ruling, and they dispute whether the facts that the trial judge felt rose to the level of a temporary custody order. They dispute that it actually rose to that level.
Can I ask you a question on the substance? This evidence, this child's statements, was used against the father, correct?
It was used on the question of whether the child's needs demanded that they be placed in the temporary custody.
It was used against the father, right? The father said, I want custody, and the department said, we want custody. And the judge said, custody goes to the department. The child was not asking to have custody. How old is this child?
There are two children. They were 6 and 8, I believe, at the time.
So the 6-year-old and the 8-year-old are not asking to have custody over themselves, correct?
Correct.
Right. So this evidence was used against the father.
Well, it may have had an adverse impact on the father. I would like to firstly say it was used against the children. It's important to note in this case that the children were...
The children were not claiming custody.
Well, they were claiming a right to be in their father's custody.
They were claiming, they were not claiming custody, correct?
They
were not claiming that their best interest was with themselves.
No, but they were claiming that their best interest was with their father. The children have a right to be in a relationship with their father. This court has recognized that. They have the same right as the father, as a matter of fact. That's what Paula stands for. The children and the father have concurrent rights. They both have an interest in their family integrity. This has been recognized by this court and by the U.S. Supreme Court.
And
the
we're certainly
children
going to help the family integrity if any statement that a child makes about a parent is used to break apart the family, correct? That's really going to help family integrity.
And that is why the statement was used against the children as a party opponent. It was used against their interest in their integrity of the family relationship with their father. The children were very vocal advocates of remaining in their father's custody.
It doesn't matter whether the children were or were not vocal advocates, because it's all children. It's all children. And the issue in the case is it in the child's best interest to be with the department or with one parent or another parent or a guardian or an aunt? Or that's the dispute.
I believe that's what's at issue at a temporary custody hearing,
and sometimes children want to be with one or the other, but the dispute is which of those adults gets custody. That's what the determination is.
Well, that is the determination the court must make. But at that hearing, the children have a clear, recognized interest in being aligned with their father. They are a party opponent to the department in that context.
They don't have a clear interest in being what's in their in being where a court determines is in their best interest.
Well, that goes to the disposition, Your Honor. They do have a second interest in being removed from a situation where they're subjected to abuse and neglect. The court has recognized a dual interest that the children have, yes.
And often children do not recognize that because they don't know what the alternative is.
Yeah,
that may be, but through their counsel they have staked out a particular position. Yes.
If the children had expressed an interest to be with their father, the father could offer the evidence, the statements of the children, as the statement of a party opponent, couldn't they?
I think that essentially, as you heard my brother concede, these statements technically fall under the rule of a party opponent, exception to the hearsay rule.
Would you object to the admission of
he may have made that concession, but I'm not so sure that he's correct. Because what's at issue in this case is custody. Custody. And the children have no say in the sense that they can't get custody over themselves. The decision may have an impact on them, but the adverse parties are the state versus whoever the adult is that has the parental control at the time.
But respectfully, if I may, Your Honor, it's important to note that our cases are not like traditional civil cases or even criminal cases. There, the parties are clearly aligned by the pleadings. There's Jones versus Smith or Commonwealth versus Franks, whatever it may be. Our cases don't have a versus in them. Our cases
We have lots of cases where there are very serious consequences for people who do not have, strictly speaking, an adverse interest, such as victims.
I guess your point
That is true, but the victims are not a party to those proceedings
Your point
in a
is that
criminal matter.
these are unique proceedings where it's not A versus B. The predominant question is, what is in the best interest of these children?
Yes, Your Honor.
The DSS has evidence that placement with the state would be in their best interest. The father says placement with me, and they have a stake in it. They get assigned lawyers, right?
Yes, they had counsel, yes.
They had counsel. So in that framework, they could be considered a party. That's your point.
That is the department's contention.
Let me ask you this, Mr. Polisa. Does it help children who may be subject to terrible abuse to have them talk to social workers, representatives of the state?
Does it help them in a general sense? I mean,
I would hope that you would want to say that counsel would be free to say, go and tell the Department of Social Services, what you saw, what you didn't see, because we want the department to have the most information that we can. But if that information is going to be used against, quote, the child, it seems to me that that's, I mean, some of these children are 12, 13, 14, 15.
And I suppose an older child like that does have the advice of counsel and can act on
That's
that.
not the advice of counsel. The question is you want counsel to be able to say, you can tell the social worker what happens because, no, this is not going to be used against mommy or daddy. It permits the department, for example, to get investigators, to get medical reports. You want children to do that, don't you?
Yeah, but, Your Honor, that's going to an issue that goes beyond this case, if I may, Your Honor. I think that's going to the question of whether there's a privilege at stake there.
No, it's not a privilege. It's a question of whether, in fact, for hearsay purposes, I'm not talking about a privilege, I'm talking about for hearsay purposes, whether or not these are not classic adverse parties.
Well, they're not classic in the sense, that is true. But there is one thing they have in common with classic adverse parties, as well as with the existing case law, if I may. And that's the question of there is no party that's actually prejudiced by the admission of these statements. These statements, coming in as statements of a party opponent, are only admissible in the event that the child, the declarant, is available to testify. Not necessarily that the child has to testify, but is available and can be called. Now, this is an important distinction.
Wasn't that the rule that we crafted with respect to investigators and court agents?
Well, that is the rule that's been crafted by this court with that respect to that.
But we put that gloss onto creating a hearsay rule.
But if I may, Your Honor, I think that's also part and parcel of the rule of statements of a party opponent. And the Department has cited to several cases on the issue of party opponent statement, which go to that point. And a review of the chapter in Liakos on that issue also goes to that point. The reason that those statements are admissible, the reason that there's an indicia of reliability is because the party cannot claim I'm unavailable to rebut the statement. The party is in court. The party can take the stand.
The father could have put these kids in the stand to say he never hit us.
Yes. Now, in the event, I do have to clarify that answer, if I may, Your Honor. And that is, there's always a question in these cases of whether the child is available or not. Clearly, the legislature understood that when it crafted General Law 233,
You mean by way of
Section.
you're talking competency?
There may be a competence question. There may also be a question, frankly, as to whether it would be damaging to the child to require them to testify. I can appreciate that, and the Department's sensitive to it. That might make the child unavailable.
Well, then, if there's proof that the child's unavailable, the evidence can be excluded.
Yes. Yes,
because
the Department.
The exception doesn't apply.
The Department agrees with that.
So either way, the father's clearly got an opportunity to rebut this.
Exactly, and that's why there's no prejudice to any party. These children were in the hallway the entire time.
Doesn't that mean that the children will be pulled in to testify?
I think the question
by their own counsel. It's not a question whether the father can pull them in. The question is, can they get pulled in?
I think the issue may be raised more often. Right now, the cases that have been cited, those cases that my brother cited, that go to the question of whether children's statements are available through court investigators' reports or through 51Bs.
We've done that because to protect children,
and
but if they're being used against, quote, their interest.
But Your Honor, if the children have the ability to take the stand and explain that statement, or to rebut the statement through their own testimony, the children are prejudiced by it. And that's what it goes to. Now, as I said, under the statute for sexual abuse disclosures, the legislature recognizes that a child may be unavailable because testifying would cause harm to the child. That could be the situation here. And I think if the department offers a statement made by the child, and one of the parties, the father or the child, seeks to call the children to testify, and the court determines that the child is unavailable for any reason, for any appropriate reason, then the statement is properly stricken in that situation. So, in essence, there's no prejudice. That is consistent, if I may, with the rules of evidence that exist in this case. Well, thank you, Your Honor.
Thank you.